Welcome back, everybody, to our studies in the law of trusts. This lesson is going to introduce topic number 8 of our videos, looking at the various different types of trusts and the ways in which the law operates within them. This video specifically is going to be focusing and taking an introduction to the concept of the implied trust, an introduction to implied trusts. Now, the topic itself, topic number 8, is going to concern itself with two different types of implied trusts. The two main types of implied trusts, as you would imagine. These being resulting trusts on the one hand and constructive trusts on the other. We'll be moving on to the next topic of conversation in this video, introducing the nature of the implied trusts, examine their importance more broadly, and then delineate the different kinds of implied trusts which exist. And as I've just noted, and made a point of there, implied trusts can be delineated at least broadly, and will be delineated at least broadly, into those two specific categories: the idea of the resulting trust on the one hand, and then the idea of the constructive trust on the other. So, the nature of an implied trust, as the name probably suggests, is that it is a type of trust which can arise without the express declaration of a trust by a settlor. So whereas previously we've been talking about the existence of the expressed trust, we've been talking about the idea here of the settlor making a decision, okay, I'm going to put some property on trust. I'm going to take some property, let's say some money in a bank account, and I'm going to place that property on trust for these beneficiaries. I'm going to hand the title to this property over to the trustee. They're going to manage that trust for me, and the benefit is obviously for the beneficiary. We're going to have a whole agreement set up and in place that tells us what the trustee can and cannot do, what should and what shouldn't be done with the property. And this is how an express trust is created, by express declaration, normally, at least in the ordinary sense of trusts being created for the most part. Generally speaking, they reflect the ability for the law of trusts to answer to the changing nature of society, this being implied trusts specifically, and the ways in which the intentions of parties may fail to actuate. So it might be the case that the intention of the parties was for the beneficiaries to benefit in equity in some kind of way, or for the property to be put on trust in some kind of way, but that this was failed to be achieved. This had been failed to be achieved through, obviously, the process of the basic nature of society, essentially, the process of the parties failing to create a trust in the nice, neat, and uniform manner that an express trust would exist in the name of. So instead of that, you might have the existence of an implied trust, even though a trust has not been expressly created, has not been expressly set up by the settlor or the testator upon death. It could be the case instead, however, that there is still nevertheless the ability for the people who are involved in this dispute or involved in this situation to still nevertheless have a trust be created. And this gives rise to this question of the types of implied trusts which may exist. We'll be spending a lot of our lessons here talking about two main types of implied trusts. We're going to begin first by talking about the nature of the resulting trust on the one hand, and then we will talk about the constructive trust on the other. Now, as just a basic overview and a basic introduction for this lesson, the resulting trust operates independently of the intention of the parties that are involved. Fundamentally, there are generally two types of resulting trusts which may exist. You have what are known as automatic resulting trusts on the one hand, and then on the other hand, you have resulting trusts which may be presumed on the other. By contrast, then, the constructive trust is a little bit more complicated, and the constructive trust is, by nature and by extension of that, a little bit more difficult to define. They don't necessarily fit into the neat separate distinction as was with the case of having a presumed resulting trust and an automatic resulting trust. Instead, they're a little bit more complicated. It is for this reason that courts and commentators, for example, such as Lord Justice Edmund Davies, argued that they have been left deliberately vague. And as a reference to that, you have the case here of Carl Zeitz Stiftung versus Herbert Smith from 1969. This is a case that deals with the question of the constructive trust, or at least makes reference to the constructive trust. And Lord Justice Edmund Davies makes the point that they are considered to be quite deliberately vague as a result of their nature, and it seems to be the case that they quite likely thrive on the fact that they are deliberately vague, and that that deliberate vagueness confers something of a benefit to the nature of the constructive trust. We'll get to all of this and what all this means in future lessons' time, however.